Hello there. I'm attorney Kelly Longtin from Kelly Longtin Law, where we provide effective estate planning for everyday families. And today I want to talk to you guys about what is a separate revocable living trust. Now, when a couple engages in foundational estate planning, one of the first questions addressed by any estate planning attorney is whether it makes sense for the couple to use a revocable living trust as part of their plan. If using a revocable living trust makes sense, an important follow-up question to a married couple is whether it makes sense for them to use a joint revocable trust or to have separate revocable trusts. Let's talk about what is a revocable living trust. You see, a trust is just a legal concept that allows an individual, called a grantor, a settlor, a trustor, or the trust maker, to transfer ownership of their accounts and their property to a trustee. And for most revocable living trusts, the trustee is the same person as the grantor. And this person has a legal obligation to use that property for the benefit of a beneficiary. Now, a revocable living trust is a trust that an individual, the grantor, creates during their lifetime. The trust can be changed at any time until that grantor becomes incapacitated or unable to make their own decisions or dies. To create the trust, the grantor changes the ownership of their accounts and property from the grantor as an individual to the grantor as a trustee of the trust. Now, as a planning tool, a revocable living trust enables the grantor to name themselves as the current trustee and designate a co-trustee or a substitute trustee to act on their behalf if they become unable to act as a trustee for any reason. A revocable living trust also allows the grantor to continue enjoying their money and property during their lifetime and to designate what will happen to that money and property upon their death. Now let's talk about what the difference between a separate revocable living trust and a joint revocable living trust is. When a married couple, the grantors, uses a joint revocable living trust for estate planning, they are typically both also initial trustees of the trust. The grantors then transfer all of their separate property and their joint property into the same trust, which typically names both of them as trustees and beneficiaries. However, they can designate which property is truly joint and which is their separate property on the schedules that are attached to the trust. Grantors of a joint revocable living trust can also designate what happens to joint and separate property at the death of the first spouse and then again at the death of the second spouse. On the other hand, when a married couple uses separate revocable living trust, two separate trusts are established, and each individual transfers their separate property into their own trust. They also typically will split their jointly owned property and transfer the resulting separate shares into their own trusts. As they acquire additional jointly owned property, the couple continues to divide the property in accordance with what they have agreed upon and transfer their respective shares into their separate trusts. Now, in some community property states, most married couples, particularly those couples who have been married for many years and have children only from that marriage, they'll use a joint revocable trust because of the important tax benefits that accrue from that community property ownership. Keeping community property in a joint trust ensures that the marital property retains these important tax benefits. Nevertheless, even in community property states, there are circumstances in which married couples may want to consider using separate revocable living trusts. Now, there's 9 community property states in the U.S. You have Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, Wisconsin, Alaska, South Dakota, and Tennessee. And these are all governed by community property laws. So let's talk about why a couple would want to use separate revocable living trust. As I just explained, although a joint revocable living trust can preserve tax benefits for those in community property states, there's also a number of good reasons to consider using separate trusts in estate planning, regardless of whether the couple lives in the community property state. One of the reasons is to have enhanced asset protection. So keeping property in separate revocable living trusts during a marriage can sometimes make it much more difficult for one spouse's creditors to access the property held in the other spouse's trust. For example, there was a case in Utah where a lumber supply company sued a husband in an attempt to foreclose on his family home as a result of a personal guarantee that he had made to the company to obtain building materials. Because the couple had decided years before to transfer their home into the wife's separate revocable living trust, of which she was the only trustee, the court held that even though the husband continued to live in the home with her, the home was beyond the reach of his creditors. Of course, this case directly applies only to Utah residents, but many of the legal principles are similarly applicable in other states. Anytime one spouse creates some level of legal separation between themselves and certain property that would otherwise be treated as marital property, that spouse strengthens the argument that their creditors cannot reach that property in a lawsuit. In addition to asset protection during the grantor's life, assets in a separate revocable living trust are even more protected after the grantor of the separate trust dies. At that time, the trust becomes irrevocable, making it even more difficult for other beneficiaries or the surviving spouse's creditors to reach the property held in the now irrevocable trust. Another reason has to do with the ease of administration at death. Administering the property of a joint revocable trust after one spouse dies requires a certain amount of effort to divide the property between the deceased spouse's share and the surviving spouse's share. The process frequently requires careful valuation of the property in the trust, as well as executing new deeds for real property, retitling stock certificates, or establishing separate investment accounts to hold the deceased spouse's separate property. On the other hand, if all of this work was done when the spouses funded their separate revocable living trusts, so if it was transferred or retitled into their property into the name of the trust administration after the death of the first spouse can be very simple and straightforward. The only task may be notifying the financial institutions of the grantor's death and providing them with the trust's new tax ID number in order to properly report those tax issues going forward. Now, couples who have been married before or who have children from another relationship, they may also benefit from using separate revocable trusts. This is particularly true when each spouse has property that they would like to keep separate for certain reasons. For example, perhaps a newly married spouse has inherited their parents' home and the couple would like to live there, but the new spouse wants to make sure that the family home stays in their own family and passes only to their children at their death. In addition to a prenuptial agreement, keeping the house in a separate revocable living trust would allow this spouse to specify exactly how that home should be used and passed on when they die. Using a joint revocable living trust to achieve the same result requires much more careful drafting and introduces a much greater potential for confusion and mistakes in administering the trust after the death of the spouse who owns the home. As you can see, using separate revocable living trusts in a marriage can make very good sense in some situations and offer a number of benefits. We have enhanced asset protection for married couples. You can simplify the trust administration process after one or both spouses pass away. You can specify and clarify the division of property in a remarriage or a blended family situation. Now, if you feel that using separate revocable trusts might be appropriate in your situation, just give us a call and we can set up a consultation to discuss that with you. So I hope you found this beneficial. I'm attorney Kelly Longtin from Kelly Longtin Law, where we provide effective estate planning for everyday families.